All right. Well, if I push the button correctly, we are hopefully live and have
Looks like we are
Stephen.
live. Looks like we are live. John, how are you doing today, sir?
Good, good. We have the Honorable Blaine Dixon with us.
Good afternoon.
Special guest, Brother Dixon in the studio. For those of you guys watching us live, this is the Hoot Show, right? It's going to be a hoot one way or another with John and Stephen, otherwise known as Legalese, with John Watts and Stephen Palmieri, and special guest Blaine Dixon hanging out down there. Put in your comments below. Get our attention. We are here with two bona fide licensed attorneys and one unlicensed comedian here to give you all the credit information you guys need. So, John, Blaine, what are we going to go ahead and what are we going to start with here today, man? What's going on?
Just watching the world unfold, and planes and tanks and all sorts of craziness happening.
All right, let's dial it back in then. Forget about what's going on over there. Let's talk about what's going on over here, because our audience is always watching the world unfold when they've got to process client files and they look at those errors and they put the CRAs and the furnishers on notice of the errors. And then 30 days later, they get neither a deletion nor a proper correction. And they are like, the world is unfolding over here. I mean, Congress said that these people are supposed to modify it or delete it, and they just gave me the proverbial royal middle finger. Let's talk about that, John and Blaine. How do we even start this conversation for our audience?
So I'll start off by saying this, that the most critical aspect is your dispute letter. And that needs to be very, very specific, very detailed, and point out all the errors, and at least all the errors that you might want to sue for if they're not fixed.
Hold on, John. Just to make sure, for those people who may not have mastered the language known as English, when you say all the errors, you actually mean all the errors. Is that what you intended to communicate to our audience?
All of them. No quotation marks. Just
so
flat out.
You didn't mean like send them like 10 letters over a year and a half and then like put one in one letter and then another one 30 days later. You meant like just slam them. Everything that's wrong. Wham, bam. Thank you, ma'am. And when it comes back, okay, then this ties it to the scenario we're talking about. Okay, you put them on notice of the errors, comes back. It's not fixed. It's not deleted. All right. Back to you, John. Sorry for interrupting, but it won't be my last time.
Oh, I know. So, but I still love you in a friendly kind of way. So.
That's right. In a bro hug kind of a way. All right, let's get focused here. Focused.
So, look, the critical thing is any error that you want to have the leverage of suing over, you need to identify in the letter. Now, it might be a page-long letter. I've got somebody that her dispute letter was 45 pages long.
Hold on a second, John. Again, I hate to be that guy, but we all know I'm that guy.
You are that guy.
Now, when you say that they need to identify it in that letter, almost all softwares in the marketplace are hugely deficient when it comes to being able to generate good letters. So how in the world are the poor consumers and the credit repair business owners supposed to send massive quantities of letters out to the bureaus when all the tools out there in the marketplace are stacked against them? How are they supposed to go ahead and load up credit files to a way where you, an attorney, likes those letters, man? Do they have to put time and effort into it?
Yeah, time and effort. And there may be a software package that somebody on this call has that may help with that. But whether you use technology, automation, sweat, whatever you use, you've got to identify those errors. And here's the problem that Blaine and I run into. We're in litigation and we see errors on the credit reports, but the dispute letter is kind of generic. And it says, oh, this is not mine, or there are errors with the account, please fix them. But it doesn't identify them. Now, first of all, we wouldn't file that suit. But if we did file that suit, we would be in a world of hurt because there's very little obligation on the credit bureaus when we don't do very detailed disputes. So I think for the credit repair organizations, they've got to decide, are you doing disputes just for credit repair and, hey, we'll just keep pounding month after month and maybe things will get fixed? Or are you doing actual disputes that if they're not fixed, you want to send those to a lawyer? And those are not the same thing. And Blaine, I know you get contacted by credit repair places who say, "Hey, Blaine, we want to send you all these cases in Tennessee," and you look at the dispute letters, and they're just garbage. They're junk. So, what do you tell those people, Blaine?
Well, I'm sorry. I mean, the only thing that we can do is that those disputes are going to have to be redrawn, before any sort of litigation can be undertaken, and we're going to have to go through those line by line through those reports, and detail. As far as what we feel that we're going to sue on, we've got to detail every single one of those inaccuracies or errors due to incomplete or missing information. And that's got to be specifically identified so the court can look at that, and the judge will look at that and say, well, whether I believe you or not, there is this objectively inaccurate, you made this assertion that this information in this line on this page is objectively inaccurate or incomplete. And there's nothing that the courts like more than an objective black and white error that they can see, or a fact that is reducible to ink on a page. What they don't like are allegations that something was wrong or inaccurate with no other substantiation for that. And
Wayne, you just opened yourself up to a big giant conversation. You said nothing that the judges like more than an objective black and white error. However, as we all know, talking to you attorney guys over there, there's nothing black and white per se about the FCRA. So what is a black, as opposed to the FDCPA, right? Where it's like, oh, you called the guy after a cease and desist, your ass is the grass. Here we have to figure out what is inaccurate, right? Because accurate is not actually defined in the FCRA. So Blaine, let's talk a little bit about, what do you feel comfortable with as far as how do you judge accuracy, and how do you articulate that to the credit bureaus and also to the judges when you're disputing things?
Great question. I think what we can do, and probably John can, his way of explaining this is a little bit clearer perhaps than I can. But when you're looking at the credit reports and it states that an item was, let's say you're looking at a TransUnion or Experian report, and it says an item was charged off in a certain month, and then you go back up the page and you find out it wasn't that month, but it was the next month or the month after. John, can you give us maybe a little clearer illustration of that?
Yeah, I'll pull up
you can share, maybe you can share your screen and we can look at that. But I believe when you see it with your eyes, it will jump right out at you.
Yeah, so this is an Equifax report. And so we've got on here, let's start back up top. So we're missing the account number here, and we're missing the balance, all these months, available credit, scheduled payment, actual payment, all this stuff is missing here. And so here's our payment history. And so if we look here, it says June 1st, 2017 is date of first delinquency. So Stephen, tell us what the date of first delinquency is.
Yeah, so that's the date that basically preceded the charge off or collection of it. And that's where that 7.5 year purge period is based off of. So it goes delinquent, then you have your date of first delinquency once it's delinquent. Now, it's interesting to note real quick segue, but that if this account had been brought back current, the date of first delinquency is removed. There is no more date of first delinquency. So it'll be temporarily there while it's delinquent. If it's brought back current, then it's removed. But if it ends up defaulting and going into permanent negative status, it stays. Also, John and Blaine, interesting to note that Equifax is the only of the three bureaus that produces that piece of data. Hint for our listening audience here today. And that's a super important data field. And so as it is currently, Experian and TransUnion just don't give that date to you. But that's how you even know if this thing is even supposed to be in here, because how do you know if it's beyond 7.5 years, John, if there's no date of first delinquency?
That's right. And we see this about, I don't know, 30, 40, 50% of the time. So it says date of first delinquency, June 2017. If we come up here, there's no data for June 2017. So how does Equifax know that's the date of first delinquency when there's not even any data there? And, we have things like date of last payment. Well, how much was that last payment? It was blank. And so, we just see this all through these reports. I'll pull up, here's an Experian one. And so this was a paid closed. We've got recent payments, missing that data. It's got all these things here where there's just no data that's listed here. And so, we have all different examples of these that we can bring up. But the point is that you've got to spend time going through this, or have software to help you do it, or a combination of those two things, to find the errors and be able to say, okay, not just some generic thing about, oh, my account is not accurate, please investigate. Like, well, no, be specific. You'd say, Equifax, you say the date of first delinquency is June 2017, but you have no data in the payment history for that. So was it delinquent? Was it not delinquent? There's all sorts of stuff missing here. And so
John, let's tie this thing. Let's hit this as a home run out of the ballpark for our audience here. Okay, so there are a decent segment of credit repair owners and even consumers who construct letters to that nature that you just described right there. They'll do like factual, Metro 2 factual type letters, and they'll put in there, the balance is missing for these historical periods, the date the payment was received is missing. There are people who do those disputes, yet they get frustrated continually, not necessarily by the bureaus, but by your people, John, the attorneys, who are like, yeah, but it's still not good enough for us to, we don't like this, we can't litigate on it. Let me go ahead and call you out, bro. What does it take for people who are doing letters like that with real errors to be able to give a case file to you? What do you look for if the dispute, let's say the dispute meets the elements that you just described? There's maybe even an image attached of the credit report to the dispute, which is great, right? We like to put the credit report image in there to put them on notice of their own thing. And in the letter, it says, you could do the disputes any number of ways. You could type it up nice. You could take that credit report and you could write on there. What's important is putting them on notice of the errors, right, John? Okay. And then so somebody gives to you, CRO comes to you and they're like, man, I've got 20 case files right here. And you look at it and it's disputes that meet those elements. How do you then determine your next steps, whether you want to move forward with it or not?
Well, so the first step is we have to see, does it actually, meet that level of dispute? But let's assume that it does. And I'll tell you this, 99% of the ones that I've ever been sent do not. But let's just assume that it does.
Okay.
Well, then we want to talk with the client and understand, okay, well, how did this affect you? And where is the client located? Because while it should be the same law everywhere, it's not the same law everywhere, because different courts interpret things differently. So how about emotional distress damages? How about economic damages? It may be different if you're in this part of the country or this part. So, I know for where I practice, and Blaine knows where he practices, what we need. And then it's just a matter of talking to the client and saying, okay, is this somebody that appears to be credible? Have they been involved in this process? Or do they say, I didn't know any letters were sent out on my behalf? Well, that's a problem. Surprisingly common problem. Okay.
Mm-hmm.
And, where they say, no, I didn't know this was disputed. I didn't authorize anybody to send this out. But let's, again, assume they're, good people and they have been engaged in this. Well, then we find out, do we have economic damages? In other words, by these accounts not being removed, did that appear to result in a lower score than they should have had? Is that upsetting to them? Can they articulate why that's upsetting to them? And are they prepared to go into litigation? Because what we don't do is we don't write a letter to Equifax and say, hey, pay us money or we're going to sue you. We sue them. That's, I learned that from a lawyer in Minneapolis named Pete Berry, that the best demand letter is a summons and complaint. Okay. So that's what we do. And so they have to be prepared to do that. And, sometimes we have clients that say, hey, I want you to sue, but I will never sit for deposition. I will never go to trial. So you have to get it settled. And we say, we're not interested in representing you because, you're saying I'm going into this battle, but I'm not taking any weapons with me. That's just foolish to do that. So that's really what we look for. Now, a lot of consumer lawyers, they want the person with perfect credit that has one negative item, and a mortgage broker, loan officer says, but for this item, you would have got the loan. Yeah, those are great. But we don't believe, Blaine and I, my partner, Stan Herring, we don't believe that everybody else should be just kicked to the curb. We think that we can make legitimate arguments for why this is upsetting to people, particularly when, Steve, and I'm curious, all your interactions with CROs, credit repair organizations, we just find that a lot of times the bureaus are not responding even when they receive the letters by certified mail. And they're just ignoring the stuff. Well, that's kind of bad for them. Now, it can affect who we can sue, because if nobody notifies the furnishers, no credit bureau notifies the furnisher, we have no claim against the furnisher under the FCRA.
Let's pause right there, because that's a pain point for a lot of CROs, what you just said, which was a good point. So, and for those of you guys watching, consumers, credit repair organizations, whatever, right? It used to be before COVID, although we all know that the CRAs were going to just do whatever with your letter, we knew that they were going to do something with your letter. And that was evidenced by the dispute results that you got back like clockwork within 30 days. Now, what I'm going to say, probably my attorney friends over here will disagree, but you didn't really have to send it certified mail, because if they sent you back a dispute result, that basically is their evidence that they did reinvestigate it. So, but now we're in an entirely different business flow with these people post-COVID. To John's point, and I'm sure Blaine's point, he's just sitting there so quietly. He's saying it telepathically. You send disputes to these people, and then it just sits in their rental trailer in the back behind Experian for 6 months. And so all that, to go to my point that I was trying to make here, John and Blaine, is that there's CROs who send things certified mail. Clearly the reinvestigation is not ending after 30 days. Let's even give them 45 days if it's an annual credit report dispute. And they can't find attorneys who like those. Do you guys like that? If you have somebody who can hand you a bunch of certified letters and prove that these dispute letters were just ignored, clearly that's a violation. Let's talk about that. And then, do you care about the contents of the dispute? Because that's not even the issue. The issue at this is they didn't even reinvestigate at all. They didn't send a frivolous notice. They didn't send you a love letter. They did nothing with it. So really, it shouldn't even matter the contents of it, because they didn't even get to the point to where they opened it, determined that they didn't like your contents, and sent you a frivolous notice. They didn't even do their part. They just kept it in the rental storage in the back shed there. So
yeah, I understand what you're saying, but it does matter to judges.
Oh, see, here we go again. Let's go ahead. Can we shoot up a poll here for our YouTube listeners, man? Who likes John Watts' answers? He gives us all the wrong answers. Okay, John, take it away, man. Talk to us, buddy.
So if you send a letter that is just a worthless letter and the bureaus don't do anything with it, a judge is going to say that was a worthless letter, because had they done anything with it, it would have resulted in nothing happening. So
hold on a second, but couldn't you survive summary judgment by saying, well, judge, you can't just make a conclusion that this is a worthless letter. This thing needs to go all the way to trial because we believe it has merits. I mean, let's talk about how do they just summary judgment say that this is a worthless letter?
Because they would look at it and say, you did not identify the errors. And so if you don't identify the errors, there's no obligation for the Bureau to do anything. So
But okay,
therefore,
let's say, I mean, but okay, and I'm being truly sincere. I know I like to joke a lot and use facial gestures in my hand. That's because I'm Italian. But the FCRA is this like ambiguous. That's right, Blaine. It's this ambiguous, vague, nebulous kind of what is accurate. And so, I mean, it's a very sincere question. How can a judge make a ruling on summary judgment saying that there's no fact to be tried here if you're like, no, I mean, we believe we did put them on notice and they didn't even give us the opportunity for them to kick it as frivolous. Like, how can the judge sit back there? I mean, let's say it's not just some garbage that says not mine, never late. Let's suppose it is some sort of a halfway decent letter. But it would seem to me that that would be the kind of thing that would have to be determined once all the facts are laid out after a summary judgment. So, I mean, and maybe I'm wrong. That's why I'm asking you guys, because that's an important thing, right? That's the sticking point for everybody watching here, is the CROs are just like, hey, this is garbage. Frustratingly, how can a judge just say, yeah, this is garbage without the facts being tried?
well, so let's take a step back. Summary judgment is when both sides put forth the facts that are either undisputed or the disputed facts in favor of whoever's not asking for summary judgment. So normally it's the credit bureaus asking for summary judgment. And the judge looks at those facts and says, all right, is there any reason to have a jury trial? Or should I just summarily enter judgment? And if, for example, the errors identified are not errors on the credit reports, because we see that where people are disputing stuff and it's like, this has nothing to do with the credit report. You're just using some form that doesn't relate at all. Then the judge would say there's nothing that a jury could look at and say the bureaus did wrong. And so it's not worth wasting the time of the court and a jury to look at this. So that's why I started off this conversation saying the most important thing is your dispute letter. Now Blaine and I are, we believe we're very good at what we do, and we like to draft these lawsuits, and we think we do a great job, and we do a great job taking depositions and all this other stuff. But honestly, if you don't have a good dispute letter, that's the foundation everything is built on.
So let's back up for a second. So what is the legal threshold, I guess, the actual standard for summary judgment decision? Like, what is in legal terms? I know it's something like a percentage of the evidence or something like, what is that?
Yeah, and this is one of our comments, and we'll start getting to our comments here. So summary judgment is if there are disputed facts. So let's take a car wreck. You and I crash into each other, Stephen, in the intersection. And I've got Blaine as a witness.
My neck still hurts.
And he says you ran the red light.
I'm completely legally blind, even though I wear glasses.
Yeah. So we say you ran the red light. You say you had the green light. So I've got two witnesses. You've got one witness. That's a disputed fact. A jury has to decide who's telling the truth. And then we look at the law. So it's both disputed facts and are you entitled under the law to have judgment in your favor? So if, for example, you said, hey, I had the green light and I was going 150 miles an hour and I was drunk with my eyes closed, you're going to lose summary judgment. Okay. So it's both the law, which gets very detailed, and the facts. And the bureaus, this is a really important point, and the bureaus pound home on this, that it's not just that an error exists. The investigation has to be unreasonable, has to be negligent. So it's not like the FDCPA where if there's a violation of the law, that's it. It has to be that the investigation was improper. Now, when we've done a good dispute letter and they don't investigate, that's easy. Okay. They did a lousy investigation because they did no investigation. But the problem comes up, and I'm just going to, Blaine's a very nice guy. I'm going to be super blunt so Blaine doesn't have to be. We get garbage from CROs, absolute garbage letters. And, I'll say, well, what are the errors with the Capital One account? And they'll like describe all these errors. And I'll say, well, why didn't you put that in your letter? Oh, well, that's just not how we do it. Well, you may be doing credit repair, but you're not setting anything up for a lawsuit when the bureaus, refuse to investigate it properly. So it all goes back to the dispute letter.
And so I know we want to talk about our buddy Shadow Smith, Eric Krim. How you doing, Eric? But real quick to wrap this up. So one point is that what you're talking about, John, just for our viewers here, is really rooted in case law, right? Because the FCRA itself, the way that it was written by Congress, says that if they don't reinvestigate, you've got negligent and willful noncompliance provisions you can pursue them for. But 60 years later, everything you just got through saying was, well, Stephen, even if they throw it in the garbage can or have it in their rental storage bin because they don't have employees because of COVID for 6 months, got to have a good dispute. Just to be clear for our viewers here, John, right? That's not the way the law is written, but that's the way it's written now with the case law. Is that fair to say?
I'm not sure. I mean, it gets into semantics some, because what is an inaccuracy? How does it have to be identified? So what I'm saying is what Blaine and I deal with every day.
Yeah.
So this is the reality, and we can like it, we can hate it, but that's the reality. Summary judgment is not specific to the FCRA. It's just anything in court, you have summary judgment. That's just a standard that's always been there. So here's a question that I'll let you guys take a shot at this. So can you actually sue for failure of accurate reporting violations? So I guess let's assume that there's no dispute. Can you sue just because there's not accurate reporting?
You would have to argue that it's reported with malice or willful intent to injure if you're just suing on the basis of the information. Is that right?
Well, so let's look at that. So let me pull this up. So this is 1681E, and this is where we get to section EB, so accuracy of report. So they're supposed to follow reasonable procedures to assure maximum possible accuracy of the information. So what every court now requires is, if you're suing under this section, the information must have been disclosed in and I'm being technical here, in a credit report. So not what we get when we pull our own credit report. It's really called a consumer file disclosure. But this has to be a third party looks at it. So if you just see an error on there, but nobody has pulled your credit report, then you can't sue under EB. Now, I can not like that, but that's the current state of the law, at least as most judges would say.
Well,
so, yeah, go ahead.
And John, one of the interesting things is that the consumer-facing report, when we order up our reports, that report that we're looking at sometimes may not be the same. It may not be formatted the same or have the same degree of detail that the report that is being seen by the potential lender would have. And so you sometimes have a problem where you look at a report and you believe it's clean, and yet the lender may be looking at their version of that or the subscriber version of that, and it may not be the same. And I don't know if I opened up another can of worms, but John, can you shed some light on that for us?
Yeah, I mean, there are different standards. One way to think about this is, it's not like there's a manila file folder with all of Blaine Dixon's credit reporting history. There's billions of pieces of data that have, identifying marks on them, like this is Blaine's social, his date of birth, his name, his address. And when they pull your credit report, they sort of reach into that room of all the data and pull the data out that applies to Blaine. Well, do they say it has to be 100% match or 99%? If my social security number is 1234, what if somebody puts 1324? Does that mean that account's not reported. So they have to decide what level of accuracy. And sometimes they have different standards based on whether it's a lender getting the report or us getting our disclosure. So it can be a challenge. It's good to get whatever the lender looked at if you can. But from a practical standpoint, what most courts say is this is, even though it's written, you shall follow reasonable procedures to assure maximum possible accuracy. Most courts say this is really not that high of standard that the bureaus have to follow because they get so many billions of pieces of data, they can't really, check them all out. But it's when you notify them, hey, here's a problem with my Capital One or Midland Funding or whoever it may be. Now they have a really heightened obligation to look at that. So, going back to our question, can you sue just for inaccuracies? You can, but it's pretty hard. Okay. I mean, there are some contexts where we do it, but it's better, I'll say 95% of the time, to dispute it. It doesn't get fixed and then you sue.
John, we have to really appreciate the courts for fixing what Congress messed up, because Congress used the wrong word. They said maximum possible accuracy, but based on what you just described, the courts have interpreted that Congress really meant minimum possible accuracy because it's a low standard, as you described. Is that what I just heard?
Probably. So let's see what we've got here. Let me stop the sharing.
Blaine's face literally just got covered up by that thing. Oh, there you are, Blaine.
Yeah, he's looking over it. So let's see. What does it mean when they say they are an arm of the state and can't be sued? This company was already sued and the judge found them not an arm. So
is this sovereign immunity?
Yeah, this may be like
governmental immunity,
child support. You're trying to sue the state of Tennessee or Alabama for child support. And that gets very complicated with immunity issues. So I'll just say that we really can't dive into that without knowing all the details. But here's a question. And Blaine, why don't you start off, and then Stephen, you talk about your experience with this. So can the credit report from monitoring services hold up in court, or do you need, Timothy says, an annual credit report? You could get it from annualcreditreport.com, or you go directly to MyEquifax, Experian, TransUnion, but getting the report directly from each bureau. What do you think about that, Blaine?
Okay, am I interpreting this correctly? Is Tim asking us about? Is he asking us about the credit report that we get when we go to annualcreditreport.com? And these are,
I think what he's asking is, like the credit monitoring reports, which are
credit, like Credit Karma.
Yeah,
right. No, those are generally good guides to determine that there may well be a problem to be looked into. But you better bet that before you file a lawsuit in federal court, or you file a lawsuit in state court, as John often does, knowing that it will end up removed over into the federal courts, you'd better have the credit reports, the real credit reports from the bureaus, either directly or through the government website, because it's a matter of best evidence. If you have something that's absolutely true, but it's coming to you from, let's say you have the information, you have it correctly, Stephen, but you got it from John, and you say, well, John said, on this page and this report on this line, Equifax said this and it said that, and this balance was this and that was that, but it actually was something else. Well, that's great. It's true. I believe you. The problem is when I go into court, the court wants to know, what did the actual report say, not what did John say about the report. And so we need that, go to that root source. And so, whenever we're going into court as attorneys, in order to be successful, we've got to have our best evidence, and that comes from the actual credit reports. And when you get those, whether you order them directly from the credit reporting agencies or you go online and use the government portal to get those, you have the best record that you can have of those consumer reports for the respective agencies.
Yeah, and the only thing I'll add to that is, we're talking about the credit bureaus who, as Stephen so eloquently described, have a pile of mail that they throw in a building or in a giant pit that they cover with mud or something.
Like a true
U-Haul trailer.
politician, you took it upon yourself to just slander and damage and throw mud at me, but you did not discredit the facts of what I actually said. Thank you.
No, I said you're very eloquent. So you're just assuming I'm insulting you. I was actually, giving you credit.
You're right. You're right.
This is like watching an elephant and a donkey have a fight. You hit me with your trunk. You kicked me.
That's right. You should join more often, Blaine. Why are you not moderating and calming us down over here, man?
Thank you. Thank you, gentlemen.
But look, here we have the credit bureaus that are so willing to, even when they sign a green card on certified mail, they're willing to go, we're not doing anything with it. So it's not a surprise that they get sued, and we come in there with a smart credit, identity IQ, Credit Karma. They're like, that's not our report. That's not our data. We have no idea if that's, what we reported. And so we get into hearsay issues, evidentiary issues. And so it's fine to use credit monitoring to get an idea of what's going on. But when you can get the real thing, that's what you need. And also, if we're trying to identify the errors, we have like 5 times the amount of data with the actual reports versus a smart credit, identity IQ. So why would we limit ourselves? Now, some people will use the credit monitoring, send out a dispute, get the results back, assuming that they come back, and then that gives them more data, and then they might dispute again, and that's a strategy. But ultimately, we cannot go to Experian and say, tell us what Equifax says, because that's not Equifax. We go to Equifax to find out what Equifax says. We go to Experian for Experian. We go to TransUnion for TransUnion. And we don't do a 3-in-1. We don't do a reseller, credit monitoring. At the end of the day, if we want to sue, we've got to have that actual data, or else we give the bureaus an excuse, and a pretty good excuse. And, I put a video up maybe 6 months ago where a federal judge was talking about this, saying, yeah, you're making all these arguments based on Credit Karma. That's not Equifax.
I want to point out something that you said, though, is interesting, right? Because you said that, well, the credit monitoring's not our data. Well, interestingly, though, mortgage reports and dealership reports aren't their data either. They're reseller reports, right? Sure. But the difference is that credit monitoring reports weren't produced for a third party, right? So you don't really have that defamation, the damages. But if you really think about it, mortgage companies don't get data directly from the bureaus. They go through an intermediary. So would you say, John and Blaine, that really the distinction there between Credit Karma and the mortgage reports is just the fact that Credit Karma is not probably a consumer report because it wasn't issued for the purpose of a third party assessing your risk? And that's really more the nature of the difference rather than the fact that it's a third party.
Yeah, I think that's a big part of it. But even those mortgage credit reports, I mean, we still need to back it all up. So if it says Capital One is reporting $1,000 balance, well, we still need to look at the actual report from Equifax, from Experian, or TransUnion, and make sure, because there are errors. Now, if there are errors with that, we might sue the reseller. We might dispute through the reseller and say, hey, Equifax gave you the correct data and you messed it up. But we just always have to think about, and Blaine described it, sort of going back to the root source here. You've got to go back to Equifax. Well, got to go back to Experian, TransUnion.
John, if I could interject, and Stephen, I think about it as a thermometer. If I'm not feeling well, if I've got a little bit of an issue, my throat's scratchy, and this was true before COVID, and I think it's true now. Thermometer is a great diagnostic tool, right? Tells you if something may be wrong, and you get these tri-merges, and you get a dealer report. Those are great things. They tell you that something's there. But if you need to know exactly what is going on, then you might want at some point think about going to the doctor, and he's going to get in his toolkit and he's going to go to the root source. He's going to get down, he's going to draw blood, he's going to do these things that need to be done. And that is going to allow you to determine the exact nature of the problem and hopefully what the fix is.
But Blaine, I thought for COVID we didn't have to go to the doctor. We just had to listen to our politicians.
Well,
Never mind. Just joking with you, buddy. Come on.
Well, no,
You're going to get my channel banned.
It depends on your make and model of politician. And as always, you have to remember your mileage may vary.
So we are not going to talk about the, how'd you describe it to me one time? The Fauci ouchie. We're not going to talk about that.
Get the Fauci ouchie. That's right. Look at that thing. There you go. You took your mask now. That's right.
Let's get a little strong. Yeah.
Let's see here. So I think we've covered this. Disputes or valid claims need to be evaluated on their merits. So we've got to do that. Kevin, hello. Stephen, John. Hey, good to see you, Kevin.
Hello to Kevin.
So here's Michelle. Very short, sweet, and accurate. Templates are a disaster. They can be useful, but it's so many people misuse them. And let's see. So I'm assuming this is Robert in response to Michelle. So I assume Robert's agreeing there. So here's a good question. Is there any limitation or cap on damages to be awarded on all this FCRA violations done by the credit bureaus and the furnishers for a given account? So like with the FDCPA, a lot of people have the idea that you can only get $1,000, which is actually not correct. But so Blaine or Stephen, what are the limitations or the caps on damages? If you've proven an FCRA violation, what can you get for that from the court?
Stephen?
Do you want to go, Blaine? Go ahead.
Oh, go ahead. Well, if we're talking about, I believe what you're talking about here is whether or not we're dealing with statutory damages versus, actual and or up to punitive damages. The statutory damages on and statutory damages under the Fair Credit Reporting Act. Help me again, John. Are they? Those are limited to $1,000, and then as we move,
it's
right. I mean, it's more nuanced than that. But if you're stuck in a statutory only, it's true. There's a dollar cap. But as you move into actual damages that have resulted, if someone was unable to qualify for a mortgage or some other damage that you can reduce to some certain, and of course the damages can be much greater.
I think kind of maybe part of the question was like, how would the dispute be interpreted as far as numbers of damages? So like if you're like, well, this is my XYZ furniture trade line, and here's the 30 data attributes that are wrong. Could that be 30 violations or one violation? How would you guys?
I would typically interpret that as there might be in that trade line. I would still think of that as one claim with one set of statutory damages. Correct me if you think that I'm off base there, guys.
Yeah. So let's take a step back on damages. So statutory damages for the FCRA, you only get those if it's willful or intentional conduct, which is the same standard to get punitive damages. So the FDCPA, when we're suing debt collectors, you can get statutory damages on any violation. FCRA, it's this very high standard to get those. So as a practical matter, it's hard to get statutory damages in the FCRA. It's hard to get punitive damages. So for most people, we're really talking about two types of damages, one being economic damages. In other words, instead of getting a 4% mortgage, I got a 6% mortgage. Well, that spread would be my economic damages. And I would take that out over 30 years. Then I would reduce that back to present value and say, okay, here's what that is. Or I lose a job. I don't get a promotion. So I have economic damages. Then the other part is emotional distress damages. This was upsetting. because I identified all of these errors for the credit bureaus, very specific. I wrote them a 5-page letter, 10-page letter, 20-page letter, whatever it is. And they ignored it. They treated me with utter contempt. Yeah, Stephen sends a letter and they're like, yeah, we don't care about Stephen. Don't even pay attention to Stephen. He's unimportant to us.
Story of my life, John. Story of my life. I'm used to it. I've got tough skin.
I want to fight for you, Stephen. I feel so bad. But no, it's in all seriousness, it's this contempt and this just utter lack of respect that they have for consumers, because we're not their customers. We are not the customers of the credit bureaus. Midland Funding is a customer. Capital One's a customer. Bank of America's a customer. None of us are customers. They don't care about us.
And that's so true. In fact, I have a good friend who worked for Experian for 15 years, and he was an expert for them. Would go around the country testifying, and he said that they were. Now here's a piece of hearsay for you, but he commented one day that he said, I mentioned to my supervisor, hey, so-and-so, why are we doing this? The consumer is being injured here. And the supervisor looked at him and said, our consumer is so-and-so, and named the data furnisher, our consumer. So they consider, the CRAs consider the consumers to be not you and not me, not all our folks that we try to help, but they consider themselves they consider the consumer to be the person or the entity buying the product, buying that credit product. And
you're the product.
This is one of the few industries where you're not the product. You believe you're purchasing a product, but you actually are the product, the commodity, and that's why they don't care. If familiarity breeds contempt, then those who are most familiar with our most private, personal and financial, and sometimes even other data, they have perhaps the most contempt for us. And that's why it's so important what we do and what you guys do, and John. So,
well, just based on framing it up like that, it just makes me feel even more warm and fuzzy that, that John reiterated that minimum possible accuracy is the standard based on what the courts have observed. So,
well, and keep this in mind that when we dispute something, the bureaus make no money. They're spending money. So they view disputes as an annoyance, an expense, an evil. It makes them no money, and all it has is risk for them and cost. Now they've gotten the cost down so low, they ship it off to a foreign country and pay, a quarter for a dispute, but still it costs them money. And they go, well, maybe it's better to send a postcard back instead of a letter because we can save on the envelope. I mean, they're trying to cut the cost as much as possible because we don't provide any income to them. So let's see here what we've got. Okay, here's one. Original creditor reporting account repossession instead of charge off. It's been over 5 years. Is there a difference between the two status? So, Stephen, why don't you take this, maybe approach it from two ways. One, is there a credit scoring difference between a repo status, a charge-off status? And then do you think from an accuracy standpoint, is there a difference between, should it be repo or should it be charge-off or should it be both? What are your thoughts about that?
Well, I think the simple way of looking at it is, was it a repossessed piece of merchandise? If it was some sort of a secured transaction that was repossessed, then it should be showing repossessed. If it was charged off without a repossession, then charged off would be better. So that's my first part. As far as the score, I'm not the FICO algorithm, but I would say that if it's not reporting accurately, that's going to be a problem for sure. Either way, if it's a negative account, that's not going to be good. But was it an actual repo or was it not? That's what I would want to find out first, Steve.
Yeah, and I think that's a very good way of looking at it. We always start with, well, is it true? Is this correct information? So it may have been a charge off kind of, going all these months, and then it's a repo. Well, then it should report a repo right there. And as far as the status goes, typically the status is going to be kind of the last action. So they wouldn't report the status being 30 days late. They would report it as a repossession, because presumably that would be the last thing that shows up on this.
Well, John, if it's supposed to be the last action, I've never seen a credit report that says tow truck hooked up my car and drove away. So we need to add that to the credit report.
Yeah, let's see here. We've got Michelle. Yeah, Tim's referring to like smart credit, identity, IQ. Let's see. This is from our one back earlier about the arm of the state. So this was a school loan furnisher. So I guess what I would say is, if this was a private company, like Capital One Bank or Bank of America making a student loan, I don't think they'd be an arm of the state. Now, if this is a state agency making the loan, then that can be different. But what I would suggest is definitely get with a lawyer who does this type of work in your state, or alternatively, the state where the identity theft happened. And because it gets very, very complicated on can we sue, for example, a state court or a state agency? Can we sue a federal agency? And that's sort of a convoluted area of the law. And it all has to do, if you sort of go back in time and you say, the state of Alabama, they're the king of Alabama. You can't sue the king unless the king gives you permission. Well, what if it's a federal claim? How about, can you sue the federal government? And so there's an amendment of the Constitution that applies to this. So I would just get with somebody in your state or where this happened and say, okay, specifically, here's the entity. Do they have immunity? And even if they have immunity, can I still sue the credit bureaus if I've done a proper identity theft affidavit, police report, et cetera? And I think you can get to wherever you need to go with that.
I'd like to add one thing. So if you're dealing with the government, remember there's on the federal level, FOIA, the Freedom of Information Act, and then there's state versions of that in all of your states as far as public records laws. And so, which you are entitled to be able to request information from government agencies. And I believe, John, right, there are ways where you can sue for violations of FOIA. Could that be a way to potentially get at a federal agency if otherwise maybe you don't have an impact point there?
It may be. I'll be honest, I'm not very familiar with suing for Freedom of Information Act situation.
Looks like we've got an opportunity for you to learn a whole new vertical, huh? Look at that. This is going to be the FOIA show moving forward.
So here we have Michelle. She's loving Blaine's accent, so that's great.
And the words of Elvis Presley. Thank you very much.
Blaine's sitting here thinking that we're all the ones with the accent, and he speaks perfectly fine. What are you talking about, Michelle?
So let's see. This is going back to, I think, the question of the actual reports or like a credit monitoring. And the shadow source, right? We've got offered into evidence, and it'll be admitted based in part on whether there's an objection. Is that objection valid or not? And let's see here. Back in May, the subscriber program of YouTuber is literally hundreds, not thousands credit for it. So because of this, that's right. Okay. So hopefully that is good for you. Smart credit pools from TransUnion, not all three. Yeah, and it's not really a flaw. It's just the reality that these credit monitoring sites are not going to go to all three bureaus typically. MyFICO is the only one that I truly know of that supposedly goes to all three, but even then you don't get all the data. And so Steve, you and I were at CreditCon this past June or whenever that was. And, there was talk about trended data. So seeing all that data for each month, what was the balance? What was scheduled payment? What was the past due? What was the amount paid? You don't get that on myfico.com. You don't get that on this other stuff. So these credit monitoring, except for MyFICO, they only pull from one bureau typically. And it's not direct, so it's hearsay. And, we're just missing the data. So that's why, for those of us who are suing, we really want the direct bureau reports. Let's see here. My scores have not increased. Nothing was removed. I asked for proof of mailing. She sent out the letters. She sent copies. Okay. But it doesn't do this. Okay. So, all right. Now the comments got kind of broken up. So I think what happened is this person, Hanbiz, saw somebody on YouTube. They had a lot of information and hired this person to send out letters. And maybe it's unclear whether those letters were sent. If I'm reading what was said, and I've seen this before with CROs, when a consumer says, well, hey, send me copies of the letters you sent out under my name. The CRO goes, oh, we can't do that. That's confidential, which is the most absurd thing I've ever heard in my life. If the letter is sent under my name, I have a right to see what.
Hold on, John. Again, I hate to be that guy, but I'm that guy. That can't be.
Can I just ask you something? Do you really hate to be that guy, or do you enjoy being that guy?
I'm conflicted currently, so it was still not a truthful statement. But that can't be. That can't be the most absurd thing that you've seen in your life. Is that more absurd than a consumer reporting agency putting up the defense that, oh, but Your Honor, you can't possibly expect us to have reasonable procedures to go through all the millions of pieces of data. Is this more absurd than that defense right there, John? Come on, give me a break. Work with me.
It's a good point. It's a good point you made.
Second most absurd. So it sounds like for this viewer, though, there may be a Credit Repair Organizations Act remedy that you may be able to.
Stephen, it's interesting that this one of our viewers brought this up. We sometimes have this happen, and one of the difficult problems is that it's a big world out there, and there are a lot of people who are in all kinds of professions, be it the law or credit repair or anything else, and sometimes sometimes promises are made, and sometimes they're kept, and sometimes they aren't. I recently had occasion to assist a client in getting a continuance in a case, and I've been contacted by a company that was supposed to be representing this person, and I wasn't very impressed with the level of work it was, and it was a debt settlement company that had a law firm that backed them, and they had enrolled probably close to $100,000 in debt, and they asked me for my opinion, and I just told the person, I said, well, they appear to be complying with the law, and they were, but sometimes they can comply with the law and still not do a real great job. So it's not always it doesn't always follow that when there's a bad result that maybe the law has been broken, but it can be difficult. So people just need to know who they're working with, and as much as they can, and be careful in the choices that they make to deal with this. But we can do give a tremendous amount of help to our clients, whether it's in the area of credit repair or if it's over in the law where John and I are. If they can do so much of a service for their clients and also for themselves by just going straight to those reports and getting right to the heart of the matter. And it's not wrong to have the monitoring services are fine, but it's like we said earlier, they're a great diagnostic tool to kind of know if something's going on, but it's really more to tell you whether or not there's smoke. But if you want to find out if there's fire, you need to get up inside the chimney and take a look and see if there's fire. So.
Let me share this. Here's a red flag. If you're hiring a credit repair place and you say, hey, will you send me copies of the letters that are going out? And they say no. I can't think of any good reason why you would want to hand over your money to that place. And if they go, well, this is a proprietary letters that we've created and it's our secret sauce and we don't want you to see it because then you won't hire us. Well, that's a terrible company. Don't use that company.
Mm-hmm.
But why, if they're so afraid that if somebody sees their precious letters, that they'll lose their business, that's a terrible business to be associated with. So if somebody is sending out a letter on your behalf, you have to see it. I can't tell you how many court cases are lost because the client is asked by the bureaus, did you see this letter before it went out? No. Did you know a letter was mailed to us? No. Did you know you had sued us? No. I thought you sued me. Just unbelievable. But if letters are going out on under your name, you need to know what those letters are. I mean, if somebody's helping you by sending stuff to the IRS and you say, hey, send me, a copy of the tax return you filed under my name. Well, that would be secret and proprietary. No, no, you have a right to that. So that would be one thing, just to stay away from a company that says, we're not going to let you see what we sent out. Because as this person said, back up to this, asked for some sort of proof, doesn't have any. So I'm now thinking she hasn't sent out any letters until maybe she did. Maybe she didn't. Only she knows. And the credit bureaus know. And if this person won't tell you, that would be very bizarre. So
well, here's what I would say though, to help our YouTube viewer there. I mean, there's a law called the Credit Repair Organizations Act. It's a very short law, governs my industry, not these guys over here, but me and this lady down here. If she took any money from you, and there's very specific contract requirements, disclosures that need to be made to you, billing requirements. And the Credit Repair Organizations Act expressly states that if the contract doesn't conform to what the law requires it to say, it's an invalid contract and you can get damages, I think trouble. Is that right, John? 3 times what you paid them?
Yeah,
so,
I think so. Plus attorney's fees. I mean, it's a very...
it's what we call a draconian. It's a draconian statute. I mean, if they really and truly have operated to harm the consumer, then and that is proven in court, they could face fines and costs and damages, punitive damages, way on up in the 6-figure category, and that's not necessarily common, but the reality is there. And I'll tell you, one in particular that I can't give you any details. It's not resolved yet. But there are companies, and I know that John is familiar with these. There are companies out there who pretend, for lack of a better word, I'm not going to be very kind here, who pretend to be in the debt settlement business, take the money and siphon almost all of the money frequently off into administrative expenses and other add-on charges, and leave the person in a worse position.
Are you describing class action attorneys? Was that what you were just talking about?
Oh, no, and not that.
Just joking, man. Come on now.
Certainly not politicians or other successful big businesses, but the folks that do that are really the bottom feeders in our in this area of consumer advocacy. And so, I would say to all our friends out there in the credit repair business, be on the lookout when you think someone has been, if they come to you, and this doesn't matter whether, John and I are not looking for these cases specifically, but your clients need to know if they've been gamed, if they've been scammed, they've been hurt and really robbed by these people, and you guys see that, don't you hesitate at all to send them to someone in their state where they happen to live, because they may be able, if there's enough bad that has been done, there are people out there who may be able to help you get relief for your clients. And it certainly says a lot for you if sometimes if you hit a brick wall, so to speak, because they've been harmed so badly before they were able to find you, that you can find someone and have these folks held responsible, because that's terrible. My client had very little debt, in a big picture, maybe $10,000 or $15,000 in overall debt, owned her own home outright, paid for, and had 700 plus credit, probably close to mid 700s. And they took her and gave her some terrible advice. And now she's been sued more than half a dozen times. Lots of stuff in default, and drove her score down into the low 500s. And it's and more than that, inflicted all kinds of pain and suffering on her in the middle of the pandemic. So we see real harm done to folks. So it's important, and our friends in credit repair business have a chance. You can help them as much as you can, and then you can encourage them if you feel like there has been legal harm done to them. You can send them in the direction of an organization like a National Association of Consumer Advocates, or along that track, so that they can do that, because it's a tough thing when you see that. And so just encourage you to keep your eyes open, because those organizations like that harm those people, they harm the rest of us in the process, because they cause them to doubt the entire system, whether be it credit repair or be it the law. The average consumer looks and they just see one big world where we're all players. They see one stage with different people coming on and off the stage. They don't necessarily recognize, it's credit repair or it's law or it's this. They feel, and rightfully so sometimes, that the whole system is rigged. So,
Blaine, is it true? John was telling me before the show started, and he may not have been telling me the full truth, but you started up an advertising campaign, and you're going to have a bunch of billboards that says, "We sue bad guys." Is that true? Is that basically what your motto is?
Yeah, well, actually, no, it's the Pete Berry model, is sue them all and let God sort them out.
That's right. You don't care who it is. You'll sue a consumer, a CRA, a debt settlement company, a credit repair
I'll sue that
company.
stump out. I'll sue that stump out there, but outside my window. Yeah.
See, that's the can-do
right.
attitude that we like to talk about right there. There you go.
That's right. Yeah, but there better be an objective error that stump is made.
So let's
and I wrote a letter outlining what that stump did before I filed it.
So here's a good question for representing ourselves in court, because we could not find an attorney. Can you do a show on how to write an effective complaint? And that is a very reasonable request, but the answer, unless something unusual happens, is no, because particularly if we're talking about the Fair Credit Reporting Act, it's very, very complicated getting the right law into the complaint, getting the right facts into the complaint. And I'll just say this, you should never file, in my view, you should never file an FCRA complaint without a lawyer, or even an FDCPA complaint without a lawyer, because you're giving up something that doesn't cost you anything. You're giving up somebody who's your advocate, who knows what's going on, who's representing you. And so it would be like saying, hey, I'm going to fight Mike Tyson in his prime, and I'm going to tie one hand behind my back. It's not a very smart thing to do. So if you're not able to find an attorney, then I would say, well, let's see who we've talked to, who we've approached, and how we approach them. And I'm not saying, Andre, you did this, but I certainly get emails, and there'll be these really long emails, and the person will say, I just need somebody with a law degree. I know the law better than you do, and I know how to argue this better than you do. So I just need you to put your name on this and shut up and get out of my way. And then they get mad because it's like, well, it's been, 30 minutes. You haven't responded. I get better things to do than to respond to that. So, how did we approach the lawyer? Did we lay out the facts? Are dispute letters good? So I would just say, if you feel like I have to file this case without a lawyer, I would just take a second look at that and say, well, maybe I don't have a case. Because look, the lawyers that do this type of work, that's how we make our money. We sue these companies and we're successful and we get paid. And so if we don't file lawsuits, we don't get paid. And so if you have a legitimate case, then either the lawyers are not recognizing it, which is possible, or maybe it's not being presented to the right lawyers or in the right way. So Blaine mentioned a website. This is Consumer
Alabama
Advocates.
Consumer Protection Attorney.com. Is that the website for him to go to?
What is it now?
Alabama Consumer Attorney.com. Is that your website? What's your website? We need to direct Andre to. See, Andre, here's the thing, Andre, while he's looking that up, the reason these two lawyers put me on the show is because I'm not an attorney. And so therefore, I'm not bound by the legal code of ethics that they are. So they can't solicit you, but I'm a salesman. And I see right there, that's an opportunity. So what I'm going to say, Andre, is reach out to John Watts. That's what he wants me to tell you since he can't tell you. Reach out to John Watts, reach out to Blaine Dixon, and let them compete for your business because they just want to help the little guy like you. Okay, I'm done, John. Go ahead.
Yeah, so if you go to this website, there's other parts to it, but if you follow that link I put in the comments, this is find an attorney. You pick your state, you pick the type of practice, and it'll give you a list, and then start talking to those lawyers. You may have to go through a number of lawyers in your state to find one that you connect with, but that's what I would do.
Well, hey, and know this. Look, John practices primarily in Alabama. I am primarily in Tennessee. That's where we're licensed. If you have trouble and you've looked on the website, and let's say you click on your state, there's a bunch of names, and you just don't know. Man, there are 30 names you don't know. Don't have a problem reaching out to either one of us. I know a bunch of people in a lot of these states, and I may be able to say to you, look, I don't know if this person will take your case. I don't know if it fits them, but I can look through this list, and here are 5 or 6 people on there that, I just know from experience, they do that type of case. And, you don't walk my primary concern in answering your question is don't put yourself in a position where you just give up because you're not quite sure. And the things John said, you do need to have a case. We need to bear in mind to have sort of our fact picture together when we speak to attorneys. But at the end of the day, attorneys like John and myself, we're still people like you. We still have questions. There are people we go to when we have questions. And so we want to make that an open environment for you. And don't feel like you have to hire us. Our concern is that you get to someone who is right for you where you live. If we do that and you get helped, then there's always going to be plenty of work out there. And if you happen to live in one of our states and we can help you and you have an issue, then we're glad to do that.
Blaine, how do they find an esteemed gentleman such as yourself?
Well, you can find me on the web. I'm, if not officially yet, soon will be listed of counsel with John's firm, Watson Herring, out of Birmingham, Alabama, although I'm operating only here in Tennessee. Or if you need to, don't call me, text me, 615-440-3746. Text is great. If I get a text, and John will tell you this, he tells folks all the time, don't call us, text us. If I see that little light go off, I know there's a text, or I feel the buzz, and I'll look on it. I may be in court, I may be in chambers, wherever I'm at, and I can look at that and go, okay, I see, I've got a text from this number. Oh, someone has a question, and I'll be able to get right back with a response. Hey, I'll be out as soon as I'm out. I'll call you. That's a very effective way to reach out.
Yeah, if our phone rings and we're in court, like the ceilings open up, these guys in black clothes rappel down, they grab us, take us to Gitmo. It gets very ugly. So
now I want to make a confession right here, guys. I once had a phone. This was before the phones were this large, but my phone was loud as hell. It was an original Motorola Droid. They were made out of metal. They were heavy. They were quality. It's old school cell phone. And I was with probably the most temperamental judge in Middle Tennessee. His name was Judge Birch. And Judge Birch didn't have sense of humor. Oh, he did off the bench. You could see him out, and have a pizza and a burger and a beer with him, whatever, go to the game. But boy, when you were in his courtroom, it was all business. And I was in there one day. I was a rookie lawyer, my first year. And I'll never forget it. He was going through docket call, and that thing went off, and it sounded like one of those 1950s DJs. It was cymbals. It was banging and beating and dinging and donging. And he looked at me and he very calmly said, "Mr. Dixon, are you finished yet?" I stood up and I bowed my head like I was going to pray, because after all, he was almost like God in that courtroom. He said, "Mr. Dixon," I said, "Yes, Your Honor, I'm afraid I'm quite finished." He said, "Your phone, please." And my phone disappeared somewhere behind his bench, and I didn't see it for 2 or 3 days, and I was getting desperate. So finally, I crafted a petition for visitation privileges with my phone and filed it with the clerk. Whereupon I was summoned into court the next morning, and he smiled broadly and told me that he had decided to give me visitation privileges with my phone, and promptly declared that I was somewhat in contempt and ordered me to bring a dozen donuts. So please don't call us, text us.
That's amazing. What a hell of a story right there.
So what about this, Steve? Trying to remove an old address, but one bureau, which is probably Experian, says it's linked to an account, and so they're not going to remove it, even though he hasn't been there for maybe 20 years.
Wow.
And he's worried about identity theft. So how does he get rid of that address by dispute? And then I'll address the question, can you sue over that? But what would you say? What's the strategy to get rid of that?
Well, if it's linked to a trade line, part of the quandary is that sometimes on the credit bureaus, they put the addresses on the top and they don't really show you which trade lines they're related to. So you need to try to figure out which trade line is related to. And then, well, the simplest thing you could do would be to call up or dispute with that furnisher and update the address to the new address. And then that way you can dispute it and it's no longer linked. That's practically, kind of like how you would get through their system. Because otherwise, what you could do, you can send them an affidavit that says, "Hey, this is not my address. I'm not associated to this address. This is an irrelevant address. Please delete it." And if they still refuse to delete it, then I'll defer the rest of the answers to John.
Yeah, so that is a very good strategy. Oftentimes, if you get a bureau that won't remove an old address, they'll say, "Well, this is connected with an account." They don't tell you what account. They just say, "Oh, it's connected with one of your 74 accounts. So good luck figuring it out." And so a friend of mine has sued Experian over this. It's like, well, wait a minute. I don't have to go investigate this. You guys have to go investigate this. Section 1681I says the credit bureaus will investigate this, not that I have to go track this stuff down.
Shall. So shall, right?
Yeah. And we wouldn't normally just sue over an old address or an old phone number. But let me just pull this back up and show something that I know Steve and Blaine are familiar with. But it's good to remind ourselves. So if we go to 1681I, this is what allows us to dispute to the credit bureaus. And it says if the completeness or accuracy of any item of information. Well, any means any. It doesn't mean
interpreted like the word maximum, which case maximum means minimum. John, how can we be sure what these words actually mean, John? I'm starting to get a little confused here.
Well, we got to bring good cases and don't give the judge a reason to make a bad order. So
that's why we like to sue. That's why we love to sue for you, so we can help you determine the meaning of those words.
Yeah. So what I would do is what Steve said about if you can figure out the furniture, and if this was 20 years ago and you only have one credit card from 20 years ago, that's probably the connection. Call them. I realized maybe a month ago, one of my credit cards, which I never used, was linked to like 3 addresses ago. I'm like, how did that happen? I didn't know they had. Now I was getting electronic, statements, so I never noticed that they had an address that was like 3 years old or 5 years old. So try to update it, then dispute it, and that may do the trick for you. Let's see. I've got a few more minutes if you guys do. Let's see here. Let me grab a couple of these. Oh, here's one from Tim. Do all FCRA violations contain Article 3 standing? So Article 3 standing is from the Constitution, and it's a doctrine or a principle that you have to typically have some type of concrete injury in order to get into federal court. Judges argue about this stuff all the time. There'll be 5 judges that rule one way, 4 that rule the other, and both groups say everybody knows that we're right, and they're reaching opposite conclusions. Generally, you need either somebody to have seen this, like a creditor, a lender, somebody pulling your credit report. Now, fortunately for most of our clients, they have constant credit pulls, soft credit pulls or credit pulls. There's no distinction in the law. But the other thing is when you pointed out an inaccuracy and it's not fixed. But the other thing is, and Blaine mentioned that this is why we always file in state court, because we typically don't have this Article 3 standing in state court. It gets removed to federal court. And then if it gets kicked out, it just goes right back to state court. And so, but if you file it directly in federal court and you get kicked out, you may have lost your case altogether. So generally, FCRA violations will have Article 3 standing, but there was a recent U.S. Supreme Court case where it was a class action, Ramirez case, and some of those people, nobody had pulled their credit report, and the court basically said, well, they don't have standing.
Hey, John, when are we going to be talking about the class action Watts-Dixon case? When is that going to make it into the history books?
Which one is that?
The Watts-Dixon
case. Which one of our many class actions?
That's right. When are we going to be talking about some good, solid class action? You guys team up and administer some justice on the bad boys, huh?
We kind of prefer to do it one cut at a time.
Death by 1,000 paper cuts.
That's absolutely right.
Let's see. So this is going back to our repo or charge off. Ask about a repo. It should be reporting charge off because law requires charge off after 120 straight days of non-payment. Well, there are guidelines about a charge off, but I would say go back to what Stephen said originally. When was the repo? Normally, not always, but normally when there's a repo, there's not a whole lot of reporting after the repossession. Now, yours may be different. And but normally what I see is that they would just report basically every month that it's a repo. Not saying there's like a new repo every month, but that's your status, is it's in repossession.
And this is where for Steve, this is your post. If you can get your hands on the Metro 2 manual, it's called the Credit Reporting Resource Guide. There's versions of it floating around. And you can look at how Metro 2, the credit reporting format standard, is designed. Basically, a repossession is a glorified form of a charge-off. You're not going to repossess a piece of merchandise that is not charged off, right? So for credit reporting purposes, it's going to show repossession because that's, like more descriptive. It's basically a repossessed charge-off, essentially. So I would disagree kind of with what you had posted up there from the advice you were given. If it's a repo, then it should be reporting as repossessed.
So let's try to do a lightning round here of comments and questions. So if cell phone companies are reporting inaccurate data on our credit report, how do we combat that? The same as any company reporting inaccurate data. You dispute it, it gets fixed, it gets deleted, or you look at suing. So there's nothing particularly special about cell phone companies.
And John, I had a question for John. Is there a specialty reporting agency for cell phones, John?
So there are some, besides Equifax, Experian, TransUnion, there are other credit reports, other credit bureaus, and some of those may pick up more of your sort of monthly cell phone reporting. So you've got like Clarity, you got DataX, you've got
NCTU.
yeah, there's a number of them.
Mm-hmm.
There's a recent CFPB report that lists not all of them, but sort of the more common ones. But they're all the same. They're all credit bureaus. They're all subject to the FCRA. And so if it's inaccurate or incomplete, you dispute it.
One thing I wanted to add is if it's a cell phone company, that's basically a utility. There's a lot of folks now, John, that are doing arbitrations on those types of accounts. A lot of their
Right.
original agreements have arbitration clauses, and I've had a lot of CROs tell me they're getting, and even lawyers. We all know our buddy Shiva over in California, right? He's starting to do a lot of that. So you may want to try first. You've got to find the errors, obviously, so dispute it like John said. But then go ahead and send them an arbitration demand. If you're comfortable with that, obviously, but that is something that may be able to get you across the finish line.
Yeah, the arbitration agreements, I'll just say this real quick. The big battle on the defense side was to prevent class actions. And so that's really what the arbitration agreement was designed for, so that you can only have one person bringing one suit. And so the argument against that is it's unfair, it's not as good as being in court. So they kind of bent over backwards to make it super fair to consumers. So like there's one arbitration agreement that if you get more than you're offered by a certain point in time, you get a minimum of $7,500, and your attorneys get double their attorney's fees. And so some of these things are very expensive for the other side to go through arbitration, and it can be very good for the consumer. So Blaine and I do arbitration. Our cases tend to be sort of bigger cases in arbitration. But yeah, I mean, and we're doing more where we may be suing a debt collector in court, and then we file arbitration against AT&T, Charter, Verizon, T-Mobile, those types of companies. So here's a charge off. Creditor continues to report a charged off status for months after accounts been closed. Is it the same as late payments reported after the accounts close? Stephen, how would you respond to that?
Well, I guess I would have to say is, what is the balance on it? Is this like a credit card, although it's closed, it has a balance? Or is it a zero balance account? Because if it's a zero balance closed account, then it's charged off. There really is no reason for them to continue to report it if it's in a final status, if it's paid, closed, charged off. So I need a little more information. But if you want to post up and let us know if there's a balance on it, that'll give us kind of a good direction forward.
Okay. Tim says, how many cases have you won just using Metro 2, if any? Blaine may have a different answer. Mine is none, because I've never tried to win a case on just one thing. You don't win or lose on Metro 2. Metro 2 is just a part of proving the ultimate question, which is, did that credit bureau, did that data furnisher conduct a negligent investigation? So we use Metro 2 as part of that, but we certainly wouldn't rely on Metro 2 and say, well, I have nothing else but Metro 2. But we wouldn't ignore Metro 2 either. So it's sort of like saying, have you won a car wreck case based on just an accident reconstruction expert?
Mm-hmm.
Well, no, we use accident reconstruction experts, but we also use witnesses. We use testimony from the defendant, from the plaintiff. So it's a tool, but it's not, the sole tool.
That's right, John. One of the important things about standards and about policies and procedures is that when we can go back, Metro 2 may not win the case, but if we can show that a credit reporting agency is consistently going against the standards. And then they're also, in the process of breaking federal law, they're at the same time, not even complying with proper industry standards and procedures that they claim all along that they're following. That just tends to weigh more heavily in favor of our client's position. So they're good tools, but they're supporting pieces to the overall picture.
Yeah, and we have here a very sage piece of wisdom that Stephen is, in fact, that guy.
I hate to be that guy, guys.
So here is, I think, Stephen, you and I talked about this, maybe the last one. So TransUnion has been on this kick lately. I guess they got some new MBA student that told them this is the way to solve all their problems. Is they are sending these letters saying, we think you're working with a third party and you should work directly with us. And so, Stephen, give us the short version of, well, is this a problem? Does this mean they won't investigate? What do I need to do in response?
Yeah, so what HonBiz is posting up here, the credit bureaus have all sorts of reasons why they kick disputes back. And they kind of round robin it every now and then. They're like, oh, which one are we going to use this month? Well, this letter that you're talking about, it doesn't exactly state what you posted in there. It doesn't state that they won't work with third parties. In fact, it says that they will work with third parties, but they need to be properly acknowledged, right? So, if you hire a third party credit repair company or somebody to work with you, they're supposed to submit that power of attorney or other legal authorization with it. And that's the problem that basically most people don't do. So, but the other issue is that this is kind of an arbitrary letter that TransUnion is sending out because it's their suspicion, right, John? Like they're just saying, because if you don't send them a power of attorney, how can they actually conclude that it was sent by a third party to start with, right? So this is just another one of their, as you guys call it, stall tactics, right? But, they're basically saying, we don't think this is a valid letter because, we sniffed the paperwork and it doesn't smell like it came from your house. It came from the other guy's house, which is kind of crazy. But then, what I would say is, was the letter sent by you or was it sent by a third party? That's what I need to figure out. If it was sent by you, well, John, how do you feel about that? If that was sent by him and the bureaus are kicking it, if you like his dispute, would that be case-worthy potentially?
Yeah, I could sue, and I have sued on that. Usually, though, we'll give them another chance. And most of the time, they send the exact same letter the second time, which makes it just beautiful. Okay. So, and what's absurd about it is they go, if you sort of press them on it, they go, well, it looks like it was a template. Well, the CFPB, they have example letters. Like there's nothing wrong with a template.
Their credit reports are templates.
Yeah. The letter they're sending is a template letter. So, of course, right. You can't appreciate any irony here. But it's like, well, you put dear sir or madam, and then you list it. Well, yeah, that's what you're supposed to do. So just crazy. So here's one. I'll take this real quick. Can you use credit monitoring as proof of an E8? So this is FDCPA section 1692 E8. You tell the collector you dispute it. They update your report. Don't mark it as disputed. I would not sue using credit monitoring because it's sort of notoriously inaccurate. And you could sue a company and then they go, well, that's not what we told Equifax. And then Equifax says, oh yeah, we marked it as disputed. Well, it's very hard to prove that unless you have your Equifax report. So we always want to get the actual report before we file suit. But if you see that it's been updated and not marked as dispute, that's a great sign. And so go grab it for free from annualcreditreport.com. And this, I don't know, that sounds like maybe Warren Maxwell or something. My letters are super secret.
That's our good friend Warren.
Mine are too. I've got 26 of them together. I call them the alphabet.
That's right.
Oh, this guy.
I'm not going to tell you what it is, though.
So this is going back to this credit repair person said, well, I sent the letters, but I didn't send them by certified mail. And so, it's sort of the question, does a credit repair place have to send by certified mail? No, there's no law that they have to send it. It's just, I think, unwise, particularly now, not to send it by certified mail. Because, again, like if we're suing, so this person here, HanBiz, says, none of my items have been fixed and none of them say in dispute. So we sue the credit bureau and say, you did a lousy investigation. The credit bureau said, we never got your letter. And we go, well, you must have, because my credit repair lady said she sent 10 letters to you. And Equifax says, we didn't get your letters. So how do we prove that they got the letters? It's very hard. Now, there are some sort of obscure ways to do it under the law, but you're just, again, you're like walking into a gunfight and you're like, and I'm going to leave all my bullets at home. Like, why do that? Let's go in with, the best possible case that we can. So, maybe you send it by regular mail. If there's some objection to certified mail and you don't get a response, we'll send it again. But at some point you have to spend the money. And I know a lot of credit repair places, they price so low they can't afford. And this is something I heard Steve talk about 2 years ago, like harping on this, like, you got to charge enough money so you can do this the right way, guys. And if you're trying to be the budget, credit repair place, you're not going to do a good job for your people. And so
just remember, guys, ladies and gentlemen, guys and girls, there can only be one low-cost leader in the marketplace. And I'm sure it's not going to be you. So if you're not the low-cost leader, then you have to lead by value and you got to price yourself up.
Yeah. So let's see here. What else do we have?
Palmieri and Associates, lead by value.
Must creditor write or charge off an account after 120 to 180 days after a non-payment, depending on open end or closed end? Well, this is one where if we had time, Stephen would break out the stone tablet, the Metro 2 guide, and we would look at some stuff there, and we'd look at some accounting principles,
flow charts.
Yeah, but just in general, how would you answer that?
Well, I feel as though like I'm in a deposition and I'm being asked to answer his question with a simple yes or no, and I'm just going to say yes, Steve. So yes, they must charge it off after 120, 180 days, depending upon whether it's open-ended, closed-ended. That's not really like Metro 2 per se. There's some regulations that cover about 5 or 6 of the big main regulators that cover most financial institutions. And so their regulatory policy is to charge it off, and that's a framework for most of the trade lines that we deal with. So yes, if it goes 180 days at the end of that month, it's got to be charged off. Sure does.
So let's see here. Who pays consumer damages? Is it the bureaus or the creditors? It's whoever broke the law and is sued. So the typical approach, I'll give you sort of 2 versions. This is what we normally do. We sue them all together. So we sue the bureaus, we sue the furnishers. Some lawyers will sue the bureaus together and then sue the furnishers individually. There's just different strategies involved. But the point is, whoever violated the Fair Credit Reporting Act, that's who you're trying to get damages from. And let's see, can you open a subsidiary law firm in Illinois? Not sure about that, but we can find somebody for you in Illinois.
Oh, absolutely.
Let's see here. Read that credit report agencies aren't supposed to report late payments to a certain time, and they're within a month. So I was supposed to send a written notice. So let me just take a quick stab at this and let you guys add on. There are some people out there that are saying that the FCRA forbids the reporting of late payments. And this is a terrible...
It's time to wake up from your nap, John.
Yeah. Actually,
time for your meds.
I've got a call coming up. This is a misreading of the FCRA. Late payments can be reported. And typically when you take out a loan, an account, they notify you that if you miss payments, they may adversely credit report on you. So I don't know of anything beyond that, I mean, other than I'll say this, if you're 29 days late, they can't report you as 30 days late because 29 ain't 30. It's 29. And Metro 2 makes that very clear that like 30 means 30. So
Unless it means 29.
there's no rounding up there. It's not like, well, you were 24 days late, Steven, so we're going to round that up to 30 days late. No, that's false. That's inaccurate because you're not 30. You're 24 or 29. So let's see here.
There is a provision that requires furnishers to send notification before they report adverse information, not the CRAs, but the furnishers. But to John's point, a lot of times that notice is in like your original contract with them. And unfortunately, even if you violate it, there's no private remedy for the furnishers disregarding that. So write to your congressman if you feel shafted, Tim.
Let's see here. 5 years adding payment to balance, balance increasing each month. That may be interest. I would say, Steve, because this is a charge-off repo, not sound like a broken record. You got to get with the lawyer in your state. That may not be allowable to keep adding interest or fees after it's been charged off, after it's been repoed, but that does depend on what's happening there. Let's see. Stephen P., how do we get in touch with you?
Look at that. I thought you guys would never ask. You can go to, my God, how many ways? You can go to Stephen at StephenPalmieri.com. You can email me there, Stephen at StephenPalmieri.com. You could also check out my training course at creditrepairtrainingcourse.com. And both of my esteemed attorney colleagues here participate in that training course as well. We've got a great group of people in there. But you can email me, Stephen at Stephen Palmieri. You can hook up with me on Facebook. You can go to my website. You can just go to Stephen Palmieri and drop me a message. Look at that good-looking picture right there as well. John, thank you for
you right there. Is that you?
That is me right there in my prime glory. About
in full ninja mode.
Look at that. Yeah. Giving a little consulting and coaching to some fabulous people in that room.
You still got your merchandise?
We do. You can get some shirts. You can get some baseball caps with my name all over it there. Now, I know our YouTube user wasn't looking to spend money with me, but I mean, you know what? If you need to get a baseball cap, what better than to get one that says Stephen Palmieri with my logo, huh? So just go to StephenPalmieri.com. But in all sincerity, you could go ahead and drop me a comment there. You can go to creditrepairtrainingcourse.com and or you could email me or Google me or Yellow Page me or anything in between.
Yeah. So this will be our last one here because I do have a call I have to make. So collection account reports collection on some months, 120 days late on my credit report. Is this inaccurate reporting? Never made payments to them. So Stephen, should a collection account be showing 120 days late for any month or for a status?
No, it should not be 120 months late. If it's a collection, assuming it's a third-party collection, right? I mean, assuming it's not like an original creditor that's in collection status, but it's a collection account. You're clearly stating that the payment history should show collection. So that should be pretty ripe, I would think, to hand off to one of these esteemed attorneys right here if they don't fix that.
Yeah, and Mark, I would just say, again, check with the direct bureau reports to make sure that that's reporting. I have seen that before, but it's pretty unusual. So just want to check that out. Let's see, provide training sessions to lawyers as non-attorney. Can I join them? I do a weekly webinar, and we have done a lot of sessions that you're welcome to look at those. When I'm training other lawyers, that tends to be, sort of a private event where we're doing that. But if there's something in particular that you're interested in, Sam, just let me know. and I am sure I have missed something here, but I think
But John, 2 posts ago, you said that was the last post. Why are you not telling us the full truth here?
Yeah, well, I've got to.
Was that the last post or not, man?
Because
What
John,
are we doing?
That is the last post, 5:44 p.m.
That's it.
So, all right, guys. Well, listen, I've got to run. It was fun. Blaine, it was a pleasure. And
peace.
Stephen, you're still that guy.
Notice he didn't say, Stephen, it was a pleasure. You're finally starting to tell the truth again. Thank you, John. John, it was okay as well.
Hey, if nothing else, we both showed up, right? We weren't confused. You know how you're always confused, Stephen, which week we're doing this? And I'm like, Stephen, how many times do I have to like pound this into your head? It's 2 weeks a month.
Second and fourth Thursdays at 4 Central, John. You got to get it right on your calendar, buddy. Our audience has it on their calendar. You don't have it on your calendar. I don't know what's up with that.
I'm working on it. On it.
Baby steps.
All right, guys.
We'll get it straight. Later, guys.